Welcome to another video from Lawyer Society. This particular video will be dealing with a very sensitive topic, but as always there will be some nuances that we lawyers or even the common public can know and should be knowing in this particular topic. But before proceeding into the video, please do subscribe to our channel and share this video with your friends after watching this completely if you find this information useful, so that we can continue making more of these interesting videos for you. You might have read in the newspapers or on the social media that very often there are cases where two people are involved in a relationship and they break up at some point, and the woman files a criminal case against the man stating he had promised to marry her and they had consensual sex, but later they broke off due to some reason. And this usually depends on the facts and circumstances of a case, and the opinion of the Supreme Court is that if the person had no intention to marry such person from the inception of the relationship but still made a promise in that regard and the consensual sex followed such a promise, then that would amount to rape. For instance, there are certain relationships where people are genuine to one another for a certain period of time, but later they break off due to various other reasons. This will not amount to rape. But on the other hand, if the person right from the beginning of the relationship, he never has the intention to marry such person, but he promises that he will marry, and then as a result of such promise, the two people have consensual sex, then such a consent will not be consent in the eyes of the law, so that is rape. Now, this particular offense was not defined in the IPC that we have today, but it has been defined and there is a separate provision for the same in the new upcoming IPC, that is the Bharatiya Nyaya Sanhita of 2023. which will be coming into force from July 1st of 2024. Now, before proceeding into the new IPC, let us first look at the existing IPC and the provision for rape under this particular act. When you read section 375 that defines rape under the IPC, you can see that the second description that has been given to section 375, a rape is said to be committed when any of the acts mentioned in the other four clauses, that is A to D, is done without the consent of the woman. As you can see in a scenario where the person has made a false promise and then the consent is being given by the woman for having sex, in such cases the sex is consensual. So can it be said that it is done without consent of the woman so as to amount to rape? But for this we have to read section 375 along with section 90 of the IPC, which reads, a consent is not such a consent as is intended by any section of this code, which means it includes section 375. If the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequence of such fear or misconception. So this particular provision, that is the section 90 of IPC, makes it evident that when a person makes a false promise, he knows that the consent that is being given subsequent to such a promise is being given based on a misconception of fact. So such a consent is not a consent in the eyes of the law. So any sex that follows after such a misconception of fact is not consensual sex, but it is rape under section 375 of the IPC. The same was established by the Hon'ble Supreme Court in several cases. You can read the case of Anurag Soni vs. State of Chhattisgarh, which was reported in 2019-13 SEC 119, where it was clearly said that if it is established and proved that from the inception the accused who gave the promise to the prosecutrix, that is the victim here, to marry, did not have any intention to marry, and the prosecutrix gave the consent for sexual intercourse on such an assurance by the accused that he would marry her, such a consent can be said to be a consent obtained on a misconception of fact as per section 90 of the IPC, and in such a case, such a consent would not excuse the offender, and such an offender can be said to have committed the rape as defined under section 375 of the IPC and can be convicted for the offence under section 376 of the IPC. So it is evident that when you read section 375 along with section 90, a rape is said to be committed based on a false promise of marriage when the accused gives such promise at the inception of the relationship, and subsequent to such a false promise, the woman consents to having sexual intercourse with the person. So that is rape. This particular case was also followed in the case of Pramod Suryaban Pawar vs State of Maharashtra, reported in 2019, 9 SEC 608, and subsequently in the recent case of Sheikh Arif vs State of Maharashtra, reported in 2024, Live Law SC 68. But what is the corresponding provision that has been given in the new IPC, that is the Bharatiya Nyaya Sanhita of 2023? For this, you need to read section 69, which explicitly makes false promise to marriage and sex as a result of such a promise to be an offence. Section 67 reads, whoever by deceitful means or by making promise to marry to a woman without any intention of fulfilling the same has sexual intercourse with her, such sexual intercourse not amounting to the offence of rape, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Here there has been an explanation that is given for the words deceitful means. Deceitful means shall include inducement for or false promise of employment or promotion or marrying by suppressing identity. My doubt with regard to the way in which section 69 has been drafted is that here it has been said that whoever makes a false promise to a woman without any intention of fulfilling the same, if such person has sexual intercourse with her, then the same, when it does not amount to the offence of rape, will be an offence under section 69. But as we've already seen in this particular video and in the discussion that we have had thus far, it is clear that when a person makes a false promise and the two people have sexual intercourse, then such an act will be a rape, and there is no scenario where it is not a rape so as to bring it under section 69. Because when you read section 90 of the IPC along with 375, it is clear that it is rape. But here it has been said that section 69 is only attracted when such sexual intercourse does not amount to the offence of rape. So this is my argument that section 69 of the Bharatiya Nyaya Sanhita has been wrongly drafted, and it will lead to a lot of uncertainty because you cannot differentiate 375 of the IPC and 69 of the new IPC, because when the consent is obtained by deceitful means or by making false promise to marry, then in either case, the consent that is being given by the woman is not consent within the eyes of law, so it is rape. So the corresponding provision to 375 that is found in the new IPC will be applicable, and section 69, I don't see how section 69 is going to work. Let me know your thoughts in the comment section. Do you think section 69 of the new IPC has been wrongly drafted? If yes, do give me your explanation of the same, and do share this video with your legal community and raise this question around so that we get more inputs. We can raise a very healthy discussion on the same. If you want more such interesting legal discussions, do subscribe to Lawyers Society and click on the bell icon for more of these interesting legal discussions. You can follow us on Spotify. We have a legal podcast there, and you can also listen to our legal podcast on YouTube. Do check out the playlist that has been given in the description box below. You can follow us on Instagram, and you can also join our WhatsApp group for legal discussions, citations, so on and so forth. I will list below in the description box all those links. Do check them out. Thank you. Until next time.